EU sanctions face a new stress test. As Russia's aggression in Ukraine enters its fifth year, a new conflict, its duration far from certain, has erupted in the Middle East. These seemingly separate crises are now colliding, testing the coherence of EU sanctions policy and exposing tensions across legal regimes. A recent drone strike on EU territory and attacks on 2 EU bases in Iraq highlighted Europe's exposure to regional conflict, while developments on Russian energy sanctions are adding new layers of complexity. In a recent speech, Commission President Ursula von der Leyen warned that the European Union can no longer rely solely on the rules-based international system to defend its interests. As she put it, the EU must build its own path and find new ways of cooperating with partners. In practice, this means that EU sanctions and those who comply with them must be agile, responsive, and ready to adapt to rapidly changing environments. The question now is, what will that path look like? And more fundamentally, what might an EU sanctions doctrine actually look like? Welcome to This Month in EU Sanctions. I am your host, Dunin-Wasowicz. In recent weeks, the EU sanctions landscape has been shaped by 2 major challenges. Sustaining pressure on Russia while political divisions within the European Union complicated the adoption of new measures, and managing the sanctions and security implications of rapidly escalating tensions in the Middle East. Together, these developments highlight why EU sanctions increasingly require a geostrategic and agile approach to compliance. As we approach mid-March 2026, the EU's 20th package against Russia remains blocked by Hungary and Slovakia. At the same time, the periodic renewal of key financial sanctions against Russia is approaching, with reports indicating that Hungary is seeking concession on energy sanctions. The question is no longer only whether new EU sanctions will pass. It is whether the EU can maintain its credibility and deterrence when its sanctions-making process is visibly under pressure, a challenge for policymakers and the private sector alike. The recent conflict in the Middle East hit closer to home with a drone strike on Cyprus, the member state holding the presidency of the Council of the European Union, and attacks on French and Italian bases in northern Iraq. Beyond the immediate security implications, these developments highlight a broader concern. Europe is increasingly exposed to the geopolitical consequences of conflicts in its wider neighborhood. Meanwhile, US-Israeli actions against Iran are generating ripple effects across several areas of EU sanctions policy. For instance, any shift affecting Russian oil, particularly after the United States eased certain restrictions, could create differences between the US and EU sanctions regimes. Policymakers and compliance teams must manage the potential divergences while preserving the integrity of the EU's energy sanctions framework. At the same time, in practice, the private sector needs to manage the conflicts in law and policy. Escalation also risks disrupting transit routes and industrial supply chains, while increasing the scrutiny of exports and trade flows that could indirectly support sanctioned actors. For companies operating across these sectors, the key challenge is agility, robust risk-based due diligence, from assessing sanctions exposure to mapping supply chain vulnerabilities and preparing for rapid regulatory change. February and March also brought several notable developments in trade compliance, including updates in EU sanctions enforcement and several key new rulings from the Court of Justice of the European Union. We'll continue tracking these developments in future episodes of the podcasts and the newsletter, which is available on LinkedIn and Substack. EU sanctions are not just a matter of policy and compliance. Increasingly, they are also driving litigation and arbitration, triggering contractual disputes, investment claims, enforcement challenges, and complex jurisdictional questions across multiple legal orders. To explore these issues, I'm joined today by Paschalis Paschalidis from the litigation and arbitration practice at Arendt in Luxembourg. Hello, Paschalis, and welcome to the program. It's really nice to have you on the show.
Thank you for the invitation, Jan. I'm delighted to be here.
Paschalis, there's been so much going on with geopolitics, with sanctions, and I know you've been very busy. Before we touch on some of the most recent issues, for those listeners and those who are watching the podcast, could you tell us a little bit about your background and your practice?
With pleasure. So I'm counsel at the Luxembourg law firm, Arendt and Medner, and I practice international arbitration mainly. But in the past, I have been an associate and then senior associate and counsel in arbitration practices in Paris, starting at Sharon Sterling and then in Gaillard, Benifat and Michel Baillet disputes, where I've practiced both investment and commercial arbitration. And I've also served as referent there at the European Court of Justice for 6 years, which is how I first got to get involved with sanctions. I was working for Advocate General Melchior Wathelet, who was the Belgian Advocate General at the time, and the first Russian sanctions case arrived at the court, which was the Rosneft case. And the big question there was more institutional as to whether Rosneft could challenge the lawfulness, or the court had jurisdiction to review the lawfulness of sanctions. And the actual sanctions question did not catch or attract that much attention as did the powers of the court question, so to speak. And from then, sanctions has exploded as a topic.
So would you say it's arbitration that brought you to EU law, or the reverse, or were you always combining the dual EU law disputes profile and interest?
Well, I guess I've been kind of falling between two stools in my life, in the sense that the university had more of an EU law background, but then I practiced in arbitration, then went to the court and then back to arbitration. So I've been kind of moving in and out of these two not very compatible universes.
And not very compatible. And I think it's fair to say that the relationship between arbitration and EU law is fraught and filled with questions and topics, some of which we'll discuss as part of this conversation. And I'm very happy also that you accepted this invitation, because you have this very unique perspective combining EU law and EU litigation with international commercial arbitration and investment treaty arbitration, which is very rare, acting both as counsel and arbitrator. Before we get into the practice and some of the questions, from your vantage point, what has caught your attention in the most recent weeks and months? Is there any particular developments affecting your practice that's been particularly noteworthy?
But affecting my practice, I would say, actually the sanctions as such affected all of our practices. When the war started, many firms decided to, like our firm did, to shut down their Moscow office. And also the amount of Russian work has just dropped considerably to the point of complete disappearance. Which is, if you ask me from a political perspective, not necessarily a bad thing. But in terms of concrete stuff, I would say it's the most pressing question at the moment in our line of work is, how do sanctions impact disputes? And in particular, how does the no claims clause play out in an arbitration, and what does it actually mean?
One way that I like to think about it sometimes is, when you approach law and drafting contracts, we put the emphasis on trying to find predictability, stability, supporting the business, put in place good arrangements, avoid surprises. And I think good contracts lawyers and good commercial lawyers spend a lot of time thinking about this. And at the same time, it seems that the whole business of sanctions is to be disruptive and impact relationships. And so I was wondering, from your perspective, how do disputes about sanctions and EU sanctions arise in the first place, typically, if you were to create a typology of what do parties fight about?
I think perhaps before we talk about the disputes as such, it's perhaps worth drawing a distinction between contractual arrangements that contain a sanctions clause and those that don't, because both actually exist. And then I would say probably most of the cases, no, not all of them, most of the cases are about contracts for the delivery of goods or services that can no longer be delivered because of the sanctions measures. And some, actually, from what I understand, from what I've understood from other colleagues, in particular in the Nordics, in the past and actually currently are also very much involved in this type of disputes, because a lot of these disputes between the West and the former Soviet countries will be adjudicated in Stockholm. Is also contracts which are affected. Well, actually, are they affected? It's the real question. Very often the parties cannot know if the contract is affected by sanctions, and because they're very cautious, they're trying to decide now, should I take the risk of breaching the contract or not, and is my interpretation of the sanctions regime reasonable or not? So sometimes it's not just about the where it is clear-cut case that you cannot perform the contract. Then there's this gray zone of cases where it's not clear whether you can or not. And then, of course, you can also have disputes about the withdrawal from Russia, for example, and disputes about, but of course, these would not be commercial disputes now. It's about investors who are affected by the measures in both countries, so EU or West European and Western investors in Russia and Russian investors in the West who think that they can pursue claims against the respective countries where their investment is located and is frozen under applicable bilateral investment treaties. And I'm sure probably I have left some disputes out of this, but I think in terms of mapping it, these are like probably the categories that have attracted most attention since the beginning of the Crimean invasion, but obviously in much larger numbers since the large-scale invasion of Ukraine in 2022.
So if we take the category or the bucket of disputes that relate to the performance or an issue with the performance of the contract, what would be the type of arguments that are made conceptually? It would be one party that's prevented from delivering, it's the other that's not able to pay. If we were to walk through someone, give a description of the disputes environment, of the issues and the sub-issues that typically come up with, what would you put in those drawers?
Well, if we were having this discussion in 2022, it would have been slightly easier because there were a lot less exceptions. Now, we're going about what the rules are, but of course there are so many exceptions in which one could fall in. So derogations from the sanctions regime. But in principle, one problem might be that you cannot pay. The contract is not affected, but you cannot pay your counterparty because it is a listed entity, and therefore you cannot make funds available to them. And the other potential issue is that the Russian party is not listed, but the transaction falls within the sanctions regulation 803, and therefore it's like the sectoral, so to speak, sanctions, and therefore the contract cannot be performed. And in that context, what happens depends a bit on the circumstances of the case, but classic questions would be, would the court or arbitral tribunal be able to deliver or order performance or order payment or reimbursement depending on the circumstances of the case. So essentially, a lot of these issues will circle around the so-called no claims clauses, so the clauses in the sanctions instruments that basically serve to shield EU operators from their refusal to perform a contract when they do so in order to comply with EU sanctions.
The no claims clause, if I remember correctly, conceptually didn't come with the Russia sanctions. It's been out there and it's present across the regimes, and I think there's some of them originally coming from UN sanctions actually. And how does would the no claims clause, historically speaking, be seen more as an argument to close the forum, to say, well, you can't bring that claim against me because it's about sanctions? Or is it seen more as a substantive prohibition that bars the party that's protected by it from proceeding with a payment? Because it seems it's not functionally necessarily the same thing, depending on how you treat it.
I think it's a very good question, and it's a very important one today, and perhaps we will discuss this in a minute. But I would say probably historically, people would look at this question in the second of the two options you laid out, so as a substantive issue. But that is, I think, no longer the case. So in a recent case, which is pending before the EU courts, the Commission takes the view that as soon as a contract's performance is affected by EU sanctions, the matter becomes non-arbitrable. So basically, you have to go to court. You cannot use the arbitration clause. But the Advocate General Biondi, who is sitting in that case, has just delivered his opinion, and he takes the opposite view, thinking that as you said in the beginning, that this issue is substantive. So the tribunal, of course, have jurisdiction, but they have to comply with Article 11, which is the no claims clause. And then the question is, what does Article 11, so the no claims clause, actually mean? Or what obligations it places on the parties and so on. But it's also perhaps worth adding that this issue doesn't quite stand in isolation, because in a sense, before this question arose in a concrete case and made it its way all the way to the European Court of Justice, what has been happening is that Russian parties are trying to get out of the arbitration clauses because they bring them to a forum in the West, where the tribunals are likely to uphold and apply the sanctions rule, whatever it is in each case. And therefore, the Russian Federation modified its civil law, its civil procedure, or commercial procedure, if you want, the arbitrage procedure, to basically say that the Russian courts have exclusive jurisdiction. As soon as a contract is affected by sanctions of the so-called unfriendly jurisdictions, the Russian courts have jurisdiction. And they can also issue anti-suit injunctions against the Western parties to, in essence, force them to litigate the matter before the Russian courts. In a very fascinating, there are several cases of this kind, but one that has caught particular attention is a case where European or Western banks started an arbitration in Paris according to the contract. The contract was governed, the loan agreements were governed by English law, and the Russian party sought to obtain an anti-suit injunction from the Russian courts to stop the arbitration. Now, the arbitration was seated in Paris, and it's not clear whether the French courts can issue anti-suit injunctions, so they went to the UK courts because the contract was governed by English law, and that created a huge discussion as to whether you can issue an anti-suit injunction when the seat of the arbitration is not in England, but the contract is governed by English law. So nothing to do with sanctions. Went all the way up to the Supreme Court, and the Supreme Court ruled, yes, you can, and that provoked a change in the law so that it would no longer be possible to do that. So the new English Arbitration Act basically accepts that the arbitration agreement is governed by the law of the seat and not by the law of the contract. Anyway, so that was one, let's say, more doctrinal discussion. But the reality was that the Western banks managed to get the anti-suit injunction from the English courts, and that brought them to a standstill with the Russian parties. But in a very Russian fashion, these anti-suit injunctions come with penalties, and the penalties are massive. What's the famous phrase of Stalin? The quantity has a quality of its own. So the amount is so big, and it can target everyone, not just the parties. It can target the members of the tribunal that have not been appointed by the Russian party. And therefore, as soon as this happened, then the banks went back to the English courts and they withdrew the injunction. Because ultimately, in a very practical term, because these injunctions, so anti-suit and anti-suit injunctions, essentially are unenforceable in each other's. So the Russian one will not be enforced here, and the European one or English one will not be enforced in Russia. Essentially means that these penalty amounts can be the subject of litigation in third states, in third countries, so which are not necessarily pro-Western. And insofar as these European operators have assets, let's say in China or in Brazil or wherever it is in India, these Russian penalties can actually be enforced.
It's very interesting because I think earlier in the conversation, as we were trying to map out the types of disputes related to EU sanctions, we started with the bucket. Well, obviously, there may be a dispute as to whether a relationship is affected by the sanctions and what the consequences of that may be. But listening to your observations about the Russian anti-suit injunctions and the potential anti-suit injunctions, it seems there's a lot of fighting about how to actually resolve these disputes.
Well, I mean, jurisdictional matters have always been contentious issues, but I think, and I don't have any statistics to back this up, but it's just my gut feeling or my assessment. I think what has changed is considerably is the attitude of the Russian parties in the following way. First of all, historically, the Russian parties would be delighted to go to the English courts. It was some kind of luxury good that they were almost purchasing, you know. Similarly, arbitration would not be, an issue because it was perceived as a neutral venue. And I think we can say now that this is gone. So I think this at least partly should explain why in all of these big matters there is this jurisdictional fight. And I think essentially for the big operators, so the big banks and the big businesses, that is even more so the case. That they will pick every single fight they can in order to their position prevail. That's my personal, as I said, feeling, and I think that the cases we've seen in the press kind of support that view.
And all of this is taking place from an EU perspective as part of the, I don't know if broader, but fundamental question of the relationship between the EU legal order and within it the special place that restrictive measures have, and the world of international arbitration, commercial arbitration and investor state. How would you characterize that relationship today? What are the main hallmarks, or how would you describe that relationship between EU sanctions and international arbitration, if it's a fair question?
Well, I think it's good that you separate commercial and investment treaty arbitration. Perhaps let's start with commercial, because I think that's what probably most people are interested in. Let's say that EU law has had an easier relationship with commercial arbitration than it has had with investment treaty arbitration. And a lot of the case law that deals with this matter historically was about things like competition law, but in more recent years, it is about sports arbitration and to what extent EU law should tolerate a system of referral of disputes to arbitration, which is systematic potentially, and therefore results in the fact that certain core EU law issues like claims, for breach of rights under the fundamental freedoms or the core of the internal market, competition law would be heard exclusively by an arbitral body sitting in Switzerland, the Court of Arbitration for Sport, and then by the Swiss Federal Tribunal. And all of that debate essentially led to a recent judgment of the European Court saying, well, insofar as the referral to arbitration is not systematic and it's not compulsory, so there is like genuine consent, submission to arbitration from both sides, then all we care about is essentially that the courts do a proper review of the awards for public policy violations. And insofar that happens, that's fine. I think the sanctions case, the recent sanction case that is before the European Court of Justice, kind of, we don't know how it will play out because the judgment is still pending, but it begs the question as to whether those pronouncements about commercial or non-state investor-state arbitration, which were delivered in the context of sports disputes, would also apply in a commercial context affected by sanctions. And that's, as I said before, the Commission came and said, actually, well, the arbitration can be a way of circumventing sanctions, and therefore the matter should be non-arbitrable. I think that would be a very bad decision for arbitration as a way of resolving international commercial disputes. And I think it's also, it would have serious consequences for the European parties. Not all of them, but a lot of them. I think the Commission seems to not consider the following, which is not all of these contracts are like that, but a lot of these contracts are about delivery of goods or services in Russia. Now, in a contract which is like that, I mean, it is normal for the Russian courts to have jurisdiction. So the arbitration clause is not really an opt-out for the out of the jurisdiction of the EU courts, as the Commission seems to think. It's actually an opt-out of the jurisdiction of the Russian courts. And I would find it very bizarre.
You're saying under traditional international,
Yes.
private international law
Yes.
principles. Okay.
Exactly, yes. And therefore, if we say the matter is non-arbitrable, but this doesn't mean that the EU courts will have jurisdiction. It means that the Russian courts will have jurisdiction. And I find that very bizarre. In a sense, essentially, especially if you take into account all this debate with the anti-suit injunctions and the fact that now we have provisions in the sanctions instruments about, the unenforceability of these Russian injunctions, and the actually, if a Russian party obtains one of these anti-suit injunctions, there's automatically a ban on doing any sort of transaction with them. So although they are not listed, they are as if they are listed. So it would be very bizarre to have all these provisions to protect EU operators from the jurisdiction of the Russian courts, and then in one go to just throw them in the Russian courts by saying, oh, these arbitration clauses are not good. Bizarrely, that's possibly the only thing the Commission and the Russian Federation agree on, because what the Commission is saying is the Russian Federation's position. These arbitration clauses are not enforceable. And I find that a very odd position for the European Commission to take.
In your view, what is the limit of the analogy, if the analogy is proper in the first place, between the treatment by EU law of how far you can go on competition law issues in arbitration and how far you can go on sanctions issues in arbitration? Is ultimately the logic analogous as to the status of EU competition law and EU restrictive measures from the EU case law, or are these completely different worlds?
I'd say they're identical. I would say there is little doubt that they're both rules of public policy, and whatever decision does not deviates from them or attempts to circumvent them, cannot be enforced or must be annulled, depending on the case. So that doesn't. I think that's not the million-dollar question in these matters. There is already case law saying that from domestic courts. There is, funnily enough, as far as I know, there is also a Russian case law saying that, in the sense that the EU sanctions are unilateral, therefore they violate the UN Charter, and therefore they're contrary to Russian public policy. So it is clear that no matter which angle you take, this matter is a public policy matter. For me, the real question is not that. The real question potentially means now the question of arbitrability that the Commission has brought up, and of course the actual meaning of Article 11, like which claims fall within the no claims clause.
So we have the performance issue and interpretation of Article 11 as an example. You mentioned the fascinating multi-jurisdictional litigation related to arbitration. And the forum, so to speak. But then there's the scenario where the arbitration moves forward, is seated in the EU, then the tribunal gets to the award phase and produces an award. From an EU sanctions perspective and EU law perspective, what's the treatment of that pronouncement? And who is going to look at it, and what is the type of scrutiny that will be applied?
Well, that depends a bit on what the award the tribunal has decided. But obviously, for example, in a scenario where if the award upholds sanctions, the Russian party can obviously seek to challenge the award in the country where the arbitral tribunal rendered the award. But I don't think that will take them very far, because if the tribunal has upheld the sanctions regime, it is very, very unlikely that the European court would interfere with that. Our opposite scenario is perhaps more interesting, where for whatever reason, the Russian party has prevailed, and then the European party, the EU party, seeks to annul the award, considering that the tribunal misapplied or did not apply the EU sanctions regime. And this is actually the type of case that is pending in the case that I've mentioned before the European Court of Justice.
I think you were about to distinguish, it seems, on the one hand, the world of international commercial arbitration and another world, the world of investment treaty arbitration. If we venture in the second world now a little bit, what does it look like from an EU perspective?
Very different, because the EU courts were were extremely hostile to the idea of intra-EU, so investment treaty arbitration. So that's another debate. We don't need to open it now. On the basis of certain decisions of the European Court of Justice, these intra-EU bilateral investment treaties have all been terminated. And there are big fights both in the EU courts and in the courts of third states about the enforcement of awards that were produced in the context of so-called intra-EU arbitrations. Now, the status of extra-EU claims, so claims between an EU investor and a third state, or an investor of a third state against an EU member state, are more complicated. The Court of Justice of the European Union has already indicated that these external investment treaties are not automatically compatible with EU law because they do not comply with certain standards. And that begs the question about the BITs we have with the Russian Federation, and actually for most countries with the USSR, because they continue to apply, which are old BITs. There are two issues, basically. One is the jurisdictional issue, which is compatibility with EU law, but not the sanctions regime. And then the next layer of complications from an EU law perspective is, okay, even if we get past the jurisdictional issue, how can an international tribunal decide on render a decision that might circumvent, so to speak, the effect of sanctions? I mean, to explain this, these cases arise out of a specific kind of measures. Although several sanctions measures are capable of producing investment treaty claims, the ones we've been seeing so far arise out of measures to freeze assets.
And so, Paschalis, maybe just as a concept for those listening and watching who are perhaps less familiar with this field, in the investment treaty arbitration context, if I understand correctly, essentially you would have an individual from a third country bringing an action, a claim before a tribunal against a member state of the European Union, arguing that whatever actions taken by that member state breaches the agreement between the international treaty between that member state and the third country of which the claimant is a national or an investor, so to speak.
Correct. So, and we have seen those types of cases. So there are EU investors who are pursuing investment treaty claims against the Russian Federation because their assets were placed under so-called temporary administration, which they consider to be an expropriation, an unlawful expropriation, and therefore a breach of the relevant treaty with the Russian Federation. And then this is a Russian restrictive measure we're talking about, this temporary administration. And then there is the opposite claim. So Russian nationals who have assets in the EU, they're listed persons, their assets were frozen, and they bring claims against the member state where the assets are located to say this is an unlawful expropriation. And these are the claims we're talking about. And because of the existence of these claims, so this second category of claims, there are provisions in the EU sanctions instruments that basically render any investment tribunal decision against the EU or the member state unenforceable in the EU. So this is the kind of the current state of affairs on that front.
And it sounds like a new frontier.
Yes, absolutely. I mean, the topic of sanctions and arbitration is a new frontier as such, but within the new frontier, we are also discovering new frontiers.
Right. And often, as you know, in the private sector, and particularly businesses, are not necessarily keen to having to test things and be the case of first impression. And one of the things we think about a lot, from my perspective, in my sanctions compliance practice, we try to think about writing good clauses to help parties have a system, a framework to deal with sanctions events, to deal with other events that may affect that relationship. And often I hear that drafting, negotiating these clauses can be painful and a bit difficult for the business. But I like to say that, it takes a little effort, but the day you have a sanctions event, you're very happy to have good sanctions clauses. I wanted to ask you, in terms of readiness, in terms of pre-arbitration, pre-disputes, if you have a client coming to you and say, Paschalis, obviously we live in a complicated, very tense geopolitical world. I need to run my business and I want to think about how to make sure that my contractual arrangements will protect me, as much as possible from an EU perspective. From the disputes side, from the disputes clauses, thinking about the sanctions, what are the things you're on the lookout for, or what are the means you pay particular attention to, and trying to help your clients, maybe not be ready for everything, but at least have some good tools to deal with events
Well,
of
I
this
will
nature.
say this with some reservation, and I hope it might provoke a reaction from you, because at this stage is kind of not a gut feeling. It is triggered by a real case, but I'm starting to believe that it's better if your contract has no clause at all than if it has a bad clause.
What type of clause, Paschalis? A bad sanctions clause? A bad
Sanctions
arbitration clause?
No. I'm talking sanctions clauses only. Now, I mean, they say the very bad sanctions clause, which basically says that sanctions are not a force majeure event, actually doesn't matter, because as far as EU sanctions are concerned, there is no court that would say, oh, because the parties agreed that way, then all of a sudden, EU sanctions don't matter. So that thing is basically as if it's not written. But what I meant is to have the scenario in which you have no sanctions clause at all, and then a scenario in which you have a clause that says that sanctions can be a force majeure, but that clause is so badly drafted that basically makes it hard to decide who bears the risk of uncertainty. As I said probably at the beginning of the podcast, one of the key problems that people face, or operators face, is to know whether the contract is affected by sanctions.
Mm-hmm.
Now, the cases we are seeing at the courts right now is cases in which there is no doubt. I mean, it is a dual-use good, for example. So we know, is it a dual-use good or no, yes or no, and then that kind of helps you. It's a clear-cut case in a sense, in as much as a case can be clear-cut. But there are other circumstances in which you can't do that. And there are, just to give a small example to people, is you. If we move out of the sectoral regulation for a second, is a question whether your counterparty, is it sanctioned or not? Their name is not on the list, but then are they owned and controlled by a sanctioned person? Try to figure that one out. Or sometimes you don't know whether your transaction is, 100% compatible or not. And if it's not obviously incompatible, the Russian party will insist that you have to perform. So for me, it is essential that these clauses are drafted in a way that they give the benefit of the doubt to the party that is trying to comply with the sanctions in good faith. And I don't believe that all the clauses that are out there do that.
It's very interesting, and your comment definitely prompted a reaction. One of the reactions is, to what extent would you say that functionally, and of course in terms of legal rights and obligations, force majeure and a sanctions clause do not serve the same purpose? You may have a sanctions issue, but not a force majeure event. You may have a very good sanctions clause, but a war starting that doesn't impact yet sanctions as such, but put you in a position where you can't deal with the contract or the obligations you've undertaken. And I'm wondering, as now we're witnessing, and we're recording this, mid-March 2026, to the east, the Russian war of aggression that has entered into its fifth year, and the conflict in the Middle East that now has, I think, opened 3 or 4 fronts, and touching on issues that are both relevant to, the sanctions from an energy sanctions perspective, but likely also affecting a lot of the contracts for relationships and projects in the Middle East. And I wonder if, for a world like this, ideally, maybe what you should aim for is, solid, robust clauses that deal with these various scenarios.
Well, I think you're right to point out that there isn't an absolute overlap. Actually, there's not an overlap between force majeure and sanctions. But sanctions clauses, in my view, are clauses that try to turn a potential non-force majeure issue into a force majeure issue, essentially. It's to excuse non-performance when certain circumstances arise. But I think your remark begs a a much bigger question, which is what is the future of this in the world we live in? Ultimately, arbitration, like any form of dispute, international dispute settlement, is about a rules-based order that is there and functions. Now, if Mark Carney is right in what he said in Davos, that now it's the end of the rules-based order, well, I'm not sure to what extent, if that is a correct assessment, and I'm not saying that it isn't, the question is what will be the value of these decisions in the future. What characterized the world that emerged after 1945 in terms of international dispute resolution was the proliferation, essentially, of the New York Convention, one of the most widely accepted conventions about the recognition of foreign arbitral decisions, essentially in commercial matters. Will this be able, will it withstand the pressures from the end of the rules-based order? I mean, okay, the convention may still be on the books, but will it actually mean anything if people take, the view that these decisions are simply not worthy of recognition because they're contrary to public policy? And public policy can mean very different things in different jurisdictions. What is contrary to Russian public policy may be fine for us, and vice versa. So I cannot answer your question, but I think it is the right one. It is not at all clear in which direction we're heading.
And even if you were to take a very transactional approach to international relations, you still need good contracts and good commitments and good.
Correct, you do. But I think there will be inevitably a reduction of volume in all of that, and possibly other ways to seek enforcement other than the ordinary good old litigation or arbitration. I mean, I don't know what these will be, but I think certain, at least operators, will want a certain degree of security before they engage into an operation of that kind.
And I think that's, this was one of the conclusions of a previous episode of the podcast when we discussed the rise of the reference for preliminary rulings in EU sanctions matters. And we were observing that, well, some of these questions raise so many issues and there's so much uncertainty that there will be fights about them, and there will be litigation, there will be arbitration, and these will be arguments made before panels, before courts, before higher courts, before Supreme Courts. And it makes it all the more important to be very close to what the courts are doing and how they're treating these questions, it seems.
Mm-hmm. You're absolutely right. I personally do not think that the sanctions will disappear. I think they're here to stay. And for me, that means that there will be a certain degree of freezing of, in inverted commas, of legal relations as well. I mean, just to give a small example of what I mean. 1917, when the Russian Revolution took place, the UK government froze the assets of the Imperial Russian government with bonds in the London market. And also there was the Russian Civil War ongoing, and the UK had participated, but as a result of the revolution, of course, there was a cancellation of debt, and therefore the bondholders would get nothing. That was the USSR's position. Now, the freezing measure stayed in place for almost 80 years until the Margaret Thatcher government and the Gorbachev government managed to reach an arrangement in which Britain basically accepted that its participation in the Russian Civil War was unlawful, and therefore it did not really have a big claim for compensation. That reduced significantly the amount that the USSR would be paying to the UK government. Of course, what the bondholders got out of this was essentially peanuts by comparison to the original claim. Now, I think when you lay down, because this is kind of relevant past experience, when you lay down this to people, I wonder if they would be willing to to even trust the dispute resolution system. Because look, this kind of freezes and it stays there for 80 years, and we will not live long enough to figure out what the answer to the question is.
On that note, Paschalis.
On a joyful note, yes.
On a joyful note, but it again, I think, highlights the importance of staying up to date, of taking a multidisciplinary approach to EU sanctions, and for the professionals, the community to get together and exchange thoughts.
I totally agree with you. I think the new, I think one key takeaway from today, at least I think for the audience, should be that we have not reached the actual battlefield. And for me, the actual battlefield in all of this is assets in third countries. And I think that's what will determine the outcome of these disputes between Russian operators, EU operators, East and West, is the risk of actually enforcing those claims against those assets, and who has more assets and therefore is more liable, or more vulnerable, if I can put it that way.
And possibly, particularly in third country jurisdictions that may have an interest in having relationships with both Russia and the EU. And we'll have to sort out how they approach this.
Absolutely. Thank you so much for the invitation. Delightful.
It was my pleasure. Thanks again, and all the best, Paschalis.
Thank you. Take care. Bye-bye.